5 seconds to go. Start. The instant appeal has been preferred against the order dated May 10th, 2022, passed by the Learned Second Court of Civil Judge Senior Division in miscellaneous case number 28 of 2021, East Coast Private Limited versus Railway Supply Corporation Private Limited. The respondent herein had filed a suit before the learned court below, being title suit number 8305 of 2014 against the present appellant for eviction and recovery of khas possession of the subject premises together with a decree for means profit and other reliefs. The appellant defendant contested the suit by filing a written statement where they categorically denied all allegations of the respondent plaintiff with some positive assertion that they have paid the rent according to the agreement and were not liable to be evicted. During the continuation of the suit, trial commenced and respondent plaintiff has produced their witness on dock and has been successfully examined and cross-examined and discharged. Since then, the appellant defendant took some adjournments for quite a considerable period of time, and when the date was fixed for examination of defendant's witness, the appellant defendant did not produce a witness, and consequently, learned court below, after hearing the respondent plaintiff, decreed the suit on 24th July 2019. By the decree, learned court below directed the appellant defendant to quit and vacate the suit property within 19 days from the date of passing of the decree. Thereafter, the appellant defendant preferred a miscellaneous case being number miscellaneous 28 of 2021 under Order 9 Rule 13 CPC for setting aside of the ex parte decree supported by an application under Section 5 of Limitation Act for condonation of delay. The matter was contested by the respondent plaintiff by filing written objections against both the applications. By the impugned order made on 10th May 2022, the learned court below rejected the application filed by the appellant under Section 5 of Limitation Act. Consequently, the miscellaneous case preferred under Order 9 Rule 13 of the Code of Civil Procedure was also not admitted. Hence this appeal. The grounds which were stated before the learned court below for non-appearance the appellants at the time of hearing of the suit are as follows. There are two directors of the appellant defendant company, viz. Shrimati Shushila Gupta and Mohit Gupta. Shushila Gupta used to look after the suit on behalf of the company. At the time of the evidence of the defendant's witness, both the directors of the appellant defendant had been staying at Delhi for a considerable period of time. Due to old age and worsening mental health of Shrimati Shushila Gupta, one of the directors, who was looking after the suit, could not instruct their advocate properly. Consequently, no steps were taken on behalf of the defendant company. However, the director Shrimati Shushila Gupta died after the ex parte decree was passed, and the other director Mohit Gupta only came to know about the status of the suit in March 2020 when execution proceeding was on the way. Due to pandemic and consequent lockdown, no steps could be taken by the defendant company and they had no intentional laches for not appearing on the date of hearing of this case. Stop.